this. So, for example, if you said at the second death it's going to be distributed equally to my children, that's the way this is going to be distributed. And if one of those children has died, on to their descendants. So basically it's kind of picking this up and giving it to the people that you intend it to go to.
What if the government goes after this trust and they're trying to set it aside?
Yeah, one of the provisions we have in here is basically says if the government tries to attack this, then the trust ends and it's distributed to the other beneficiaries. It's designed to make sure that, again, if they're on a government program that's paying for their needs, that this is going to cover is things above and beyond that. And if the government tries to say no, that you need to exhaust this for their basic needs that the program pays for, they're saying in the trust, no, go ahead and pay to our other beneficiaries instead.
The next section is trustees' powers and duties, and we're not going to go through each power. I would ask that you take time to kind of browse through these powers. You're trusting us to put in here the powers that your trustee will need to deal with the trust assets, possibly for years to come. And I always equate it to you're designing a robot, and you want this robot to do particular things. But if you don't program the robot to do that, it's not going to be able to do it. For example, if I'm building a robot and I think I have it all done and I take it home and I present it to my wife Barb and she says, wash the dishes, robot, and I didn't program it to do that, it's not going to wash the dishes. So that's what these powers and duties are all about. It's trying to give the trustee the powers that we need. Now, there's a couple of powers I do want us to spend time on, and I'll refer to this by letter. In my document, it's letter II on page 15. And that's the ability for the trustee to keep a residence for your surviving spouse. And that includes purchasing a new residence or a different residence. I die, my wife Barb decides that she doesn't want the house that we have, it's too big for her or whatever, she can't maintain it, she wants something smaller, the trustee can do that with my trust assets and hold it. The trustee can take control of paying the taxes, the insurance, the maintenance, that sort of thing to provide it. Then that is dealing with the spouse. Oftentimes it's held as part of the marital trust, it can be held as part of the family trust. That is important. We wanted to bring that up because that is sometimes something that causes a little bit of uncomfortable feelings for a surviving spouse, but that power is put in there so that the spouse doesn't have to worry about a place to live.
The next power we want to talk about, again, we're skipping over a lot of these powers, so if you read through those and you have questions about them, feel free to let us know. Mark them with your pen and then just talk to us about them.
Right.
The next power is an optional power. Recall that in the beginning of the trust document, I mentioned another optional power, which was general gifting limited to that IRS annual limit. We would have talked to you at the same time that we talked to you about gifting. We would have talked to you about what we call catastrophic illness gifting. And that's a special type of gifting that occurs only when you have a major illness that's going to have a major impact on your finances. So if you've told us that you want that provision included, then this is where it would be, and in mine it's Article RR on page 18. It's going to be different for you, but you're going to be looking for a power right around the RR section of the document that starts, should I become ill with a catastrophic illness. So I'm just going to go through that for those of you that have selected it, and it's in there. For those of you that didn't select it or are still thinking about it, after I go through this you can kind of decide whether you want that provision in or not. So it says, should I become ill with a catastrophic illness? Defined as an illness which is reasonably anticipated to last 6 months or more and which renders me unable to manage my financial and business affairs as determined in writing by my attending physician or in need of full-time care, and healthcare costs threaten to materially deplete or exhaust the trust estate. The successor trustee may take whatever actions are required to preserve the maximum amount of trust estate for my benefit and for the benefit of the beneficiaries of the trust estate. And this may include the decision to create some sort of irrevocable special needs trust and or make a lifetime gift, whether or not such gift exceeds the then applicable annual exclusion amount for gifts. So what we're saying is, if you have some sort of catastrophic illness, and typically this comes up when people are going into the nursing home because maybe they've had Alzheimer's or some sort of other age-related illness, but it could be other things. And that illness is going to last a long time, 6 months or more. and it's going to have a material effect on your finances. It's either going to eat away at most of them, or it's going to eventually eat away at all of them. Then you're saying in that situation the trustee can give away all of your assets to your intended beneficiaries without regard to that annual IRS limit. So you got to keep in mind that even though we were putting this provision in, it doesn't necessarily protect you from Medicaid claims or nursing homes. The first thing you have to remember is there's a look back period for Medicaid that would come into play here. But what this provision does is give your trustee flexibility to take advantage of some planning should the need arise. It's not going to fix everything, but it takes care of giving them an option at least to do some planning. The next article up.
Before we jump into that, just a couple of other powers that you may find in your document. One is an option to buy. If you talk to us in our drafting meetings and said, well, I want to give my son, my daughter an option to buy certain property, you'll find that in the power section, so please take time to look for that. The other power that you may have is if you wanted to appoint someone to be your farm manager. If you are people that are involved in farming and you may have particular people that you want to be the manager in the event you can't manage the property anymore, you're going to find that in the power section too. So the option to buy farm managers may also be there.
Right, and if you've told us that you want somebody to have an option to buy, make sure that power is in there and it talks about what we had talked about with you.
The various terms, yeah.
The various terms about how long they have and what the price is going to be and things like that. If it's not in there, let us know. The next article, in my document, it's Article 11. Yours, it might be something else. It's called Collection and Transfer by Successor Trustee. Basically, what this article says is you're giving your successor trustee, in other words, at this point you've already passed away, whoever is running this trust after you has the power to collect assets, re-register them in their name as trustee, and deal with the public and other entities about getting that stuff re-registered and administered properly under the successor trustee's name. And it also says that the successor trustee doesn't have to give a full copy of your trust to any of those institutions. They can just give something in writing saying that I am the trustee and give certain pages of the trust basically to them to make that entity comfortable with the idea that this person is in fact the trustee who has these authorities.
If you get stuck in a situation where they're just, whoever you're dealing with really is insisting on a copy of your trust, I would tell you to hesitate on that. Call us, talk to someone in the office. We can do a trust affidavit also. Right,
and again, there's no reason for some entity out there to know exactly what you're doing with the distributions of your trust. They should be able to get by with whatever we're giving them. Okay, the next article up is called Trustee Employment Provisions, and this is where we start talking about who's going to serve in the trustee capacity after you can't serve, either because you passed away or because you become incapacitated. And again, you're your own trustee during your lifetime, so long as you're alive and competent, you run the trust. So the first paragraph there in A, it says a trustee can resign by giving 60 days written notice. You can't force somebody to serve. If you've named somebody and they don't want to do it, or if they started doing it, decided they don't like it, or they can't handle the job, they're free to resign. You can't make them serve indefinitely. The next paragraph is optional. And if you've told us that you want your beneficiaries to have the right to fire a trustee, then the next provision should say at any time or times the persons described in paragraph D may remove with or without cause any acting trustee by written notice to the trustee. So that basically gives your beneficiaries the right to fire a trustee for any reason or no reason at all. Now, if you've told us that you do not want to have your beneficiaries have that right, then that provision would not be in this document. The next provision up would be your successor trustee. This is the person that you've named or persons that you've named to serve after you. And it says that I appoint whoever you've appointed, make sure I've got their name and address correct, as successor trustee, provided that should my said person, whoever that is, cease to act, the persons described in paragraph D, or it would be C if you didn't include the right to fire, shall appoint any one or more of my descendants or any corporation authorized under the laws of the United States to administer trusts. Then you'll have a sentence that says each of the individual trustees must have attained the age of, and there will either be a blank there if you haven't told us, or if you have told us the ages that you want people to get their trust later on, for example, the grandchildren ages, then that age would be filled in there. And then we say that each successor trustee has the powers and discretions of their predecessor. And then we follow up with saying that no matter what else I've said, my spouse cannot serve. So make sure in that last sentence your spouse's name appears. The reason we don't want your spouse serving is we don't want the IRS coming in and saying that since your spouse has full access to this trust, we're treating it as if it's a part of their estate. So it gives a little bit more separation. And that's why it's important to pick successor trustees that your spouse is going to get along with. We want to make sure they're not going to have problems after your death with dealing with the trustee.
And that's particularly applicable to the family trust.
Exactly. The marital trust, you have full rights to that, and you can take that stuff out just by telling the trustee to give it to you. The family trust, you do have those additional restrictions placed on you, so it's very important, like Roy was saying, to be able to get along with that trustee. The next paragraph says that the notice to resign that we talked about in paragraph A, the notice to fire, or the notice to appoint a new trustee is going to be made by you if then living, otherwise by majority of the beneficiaries to whom the income of the trust then is or may be paid. So basically, if somebody's going to fire a trustee, it has to be a majority of the income beneficiaries that get to do that. If somebody's going to appoint a successor trustee that you haven't already named, then it's got to be a majority of the beneficiaries that do that. The next article up is the life insurance provisions. I'm not going to spend a whole lot of time on this, but basically what it says is your trustee has the right to deal with life insurance policies, deal with beneficiary designations, collect money, do whatever they would need to do to manage and administer life insurance policies. They can settle claims with them, do all those sorts of things. The next article is called Amendments and Revocation. And basically what that says is you have the right during your lifetime to amend or revoke this document. You can make any changes you want to make. You can take assets out of this trust, decide you don't like it, and get rid of it entirely, and everything's going to be distributed out of the trust as you direct. So you have full control over this trust during your lifetime, including the right to change it or terminate it. The closing article is the last article, and it basically says that Illinois law is going to govern this trust. After that, you're going to be dating and signing when you come in to have your signing appointment. So no need to date or sign the drafts that you have, but make sure I do have your name spelled correctly, and it should say declarant/initial trustee because you are the person setting this up and you are the initial trustee. And then the last page is the notary page, where we'll have your name in there, and then we will be notarizing this when you sign it when you come in.
Now we're going to move on to your will, so you'll have to look at your packet of documents and find your last will and testament. Any more?
Okay, so the primary document in your estate plan then is your trust that we just talked about. The will is kind of it covers a couple of little things, but mostly it's designed to be a safety net. You should have put all of your assets into your trust during your lifetime, or pretty much all of them. There's a couple exceptions that we're going to talk to you about during your funding meeting, but generally speaking, your assets are going to be in your trust. And the will is really designed to take any assets you forgot to put in your trust and get them over there, with a couple of exceptions. The first thing I want you to do is, at the top, it should say last will and testament of, and again, make sure your name appears there and it's spelled correctly. Then in the first paragraph, it should say I, your name and address should appear. Make sure, again, I've got that stuff correct. And it says, make this my will and revoke all my prior wills and codicils. A codicil is really just an amendment to your will. So if you create this will and 10 years down the road you make a change to it, you want to name a different executor, for example, we're going to do a codicil, which is just a change. We're just going to change that provision. So what you're saying here is you're revoking any will you've done or any codicil you've done in the past, and this becomes your new will. Article 1 is interment, and that paragraph talks about how you want to be buried and have your funeral and burial costs handled. Now, if you've decided to be cremated, this is where we'll have spelled that out, and we will also have said what you want to have done with your ashes. If you want to be buried, again, this is where that'll be spelled out. And if you've got your own lot or monument already done, we will have noted that here, and it's important that you let us know that so that we can put that in the document so that your executor is not running out and buying a lot and a monument if you've already done that. Article 2 is the personal property article. You can treat personal property however you want, and everybody's document is going to be a little bit different here, but generally speaking, most people say I leave all my personal property to my spouse. And if my spouse isn't there, I give it to my children in equal shares. And if a child of mine has died before me, their share goes to their kids. But my children pick the share of property that makes up those grandchild shares. The reason we set it up that way is our general opinion and thought, and that of our clients, is your children are more closely related to your personal items than your grandchildren are. People generally want their grandchildren to get an equal share, but sentimental items they want their kids to have, they want their kids to be able to make the decisions as to who gets what. So that's generally what we said in the personal property article. Now, if you've told us different things, that you want specific assets to go to specific people, maybe you want a gun to go to somebody, or an engagement ring or whatever, then we may have listed it here. We may have also listed it in the personal property section of the trust. So look for it in one of those places.
We also mentioned a memorandum in there too.
Yes, the last sentence or two of the personal property article says that you may leave a memorandum, which is not a part of your will, listing some items you wish certain persons to have and you request but don't require that be followed. So if you say, for example, I want my 22 gauge shotgun to go to my son, and we put it in here, then that's binding on everybody. If instead you don't do that because you think you might change your mind later, you might sell that gun, whatever, then some people decide to leave it just on a memorandum. And if you want to do that, let us know. We can give you a copy of those and you can fill them out whenever you want. If you fill one of those out, it's not binding on your estate legally, but if everyone gets along, they're probably going to follow that.
Now there are some clients that want it to be binding, and if you want to do that, you must do the memorandum before you sign your will. It must be dated before your will. Your will must refer to that signed memorandum.
Right, and in that case, it might be just easiest for us to put it in the will, but that's up to you. We can talk through that if that's something you want to do. One of the benefits about using the memorandum is you can rip it up and do a new one anytime you want. Again, it's not necessarily binding, but it will help your beneficiaries sort things out at your death. Now, if you have children, we would also have listed the names of your children as of the time of writing this will, and make sure if we've done that we've got their names correct, and it's usually the last sentence of that paragraph. The last paragraph in this article says, notwithstanding the foregoing, distributions of personal property, the following types of property are not included in that: money, securities for money, chose as an action, which is basically a right to a lawsuit, stocks, bonds, accounts, other things like that. You're saying those sorts of things are not what I meant by personal property. Instead, those sorts of things go with the rest and residue of my estate, which is under Article 3, called the rest and residue article. And it says you give and bequeath the residue of your estate to the acting successor trustee of the trust created by you, known as the declaration of trust, and your trust name should appear there. So it should say your name, declaration of trust dated, and again we're going to have a blank there because you have not come in to sign yet. Now if you already have a signing appointment dated, then it would be filled in. And it's given it to that trust as is in effect at your death. So what we're basically saying is handle all my personal property at my death the way I've said in the prior article or in my trust, and then anything else I might have in my individual name, that was a mistake. Executor, your job is to pick that stuff up and give it to the trustee. The trust is where it belongs, that's where it should have been, that's where my primary distribution plan is, so go ahead and get it over there. That moves us into the survival article.
Now, the survival article we talked about earlier in the trust, as you will recall. The first sentence in the survival article in your will should match what you have in your trust. So if you're saying your spouse is to be deemed to have predeceased you in a simultaneous death situation in your trust, that's what it should say in your will, and vice versa. Now, it goes on with one more sentence in your will. It says, no other person named or described in this will shall be deemed to have survived me unless he or she is living on the 30th day after the day of my death. So that would be any children, any other beneficiaries you may have named. The reason that is put in documents is to prevent unnecessary costs in the event of a family tragedy, a house fire, or a car accident, where there's deaths close in time and you're probating multiple estates. There's no sense in doing that, so it helps to prevent that. The next clause is the executor appointment and powers article. Here you're appointing your executor, and typically these are going to be family members that you're appointing. So again, please look at the names, please look at the addresses and make sure everything is okay. If there's anything that needs to be changed, please take your pen and mark that change and let us know. Following the appointment of the executors is the executor powers. And this is similar to what you have in the trust. in the administrative provisions and in the trust powers provision. Letter A on your executor powers is dealing with the expenses. The government wants to get their part by way of taxes, and there's going to be debts. You could have no debts, no bills, nothing. The instant of your death, you're going to have some. So you're saying, I want those taken care of, the funeral bill, funeral lunch, funeral flowers, those things all need to be taken care of. You may have an outstanding mortgage, you may have a car loan, all those things need to be dealt with, and then the taxes. So you're giving your executor the power to deal with those. If you followed our instructions on funding and so forth, there shouldn't be anything here that really is going to cause that power to be needed. But again, this is a fail-safe type document. We want to make sure we've got everything covered, so that's what that is for. Letter B gets into some of the more standard provisions, but again, these aren't going to be needed if you put everything into the trust. To sell at public or private sale, to settle claims, to make elections affecting taxes. So just by going over those few powers, you can see it's basically the powers that you had given to the trustee in your trust. Again, we have them here just in case. Once we get through those powers, you'll see, as Maury indicated on the trust, you're going to be dating the date you are signing the will. You're going to sign it. But a little bit more detail when you sign the will as opposed to signing the trust. It has to be witnessed. That's why we've asked you, if at all possible, to try to schedule the appointment for signing here in our office. Our staff members will be your witnesses. It flows a lot more smoothly if we have everyone available that we need. If you look closely, you'll see that 2 witnesses are required. We do put the witnesses under oath, and their signatures are notarized. It just helps to process the will, if at all necessary, for probate purposes at the time of your death. So you need to be here, 2 witnesses and the notary. And again, that's why we like to have a schedule here in the office. All right, so that concludes our review of the will and the trust. Again, we urge you to mark down any questions that you may have. Please let us know that you did get through the documents, you have reviewed it. Talk to one of the staff members, talk to me, talk to Maury, let us know you're done, let us know any questions you might have. We may need to schedule a follow-up appointment to have you come in and discuss some of your questions. It just depends on how major these questions are. Oftentimes you can talk to Melissa here in the office. She's very good at working with you on any drafting questions, any minor changes that you may need, and she will direct you in the proper direction.
Right, and after that, if we need to talk to you and have a follow-up, we can do that, or we can move into scheduling you for signing and funding.
Very good. Thank you.